So good evening, interns. Hope you all are doing well. Today we have amongst us Miss Meenu Pada ma'am. Ma'am is a lawyer and president at National Child and Women Development Council at Jammu and Kashmir. She's currently practicing at JNK High Court. Ma'am is also vice president at National Council of News and Broadcasting. She has been an ambassador of an international child abuse prevention program, and she has her own organization, and she's a founder of Masti Ki Pathshala, which is a school for unprivileged children. We welcome you, ma'am. So today, ma'am is here for a session to deliver a session on how to draft a writ petition. So please be careful while hearing the session, and you can post your queries in the chat box, or you can unmute yourself one by one by raising your hand. Okay. So let's begin the session. Over to you, ma'am.
I don't know whether it is available in Zoom or not, but can I share my screen? I have made a presentation regarding this.
Yes, ma'am. Yes, ma'am.
Okay. Is there any option available?
Yes, ma'am. You can click it on share screen.
Okay.
Are you able to do so?
It's not, actually, the option is not available here.
Ma'am, have you joined through your mobile phone?
Yes, I have joined in mobile phone.
Okay, then when you'll click onto the three dots, you'll get an option to share. Okay, ma'am, can you please share it with me? I'll share my screen.
Yeah. I'm sharing it with you.
All right.
Yes, Riddhi, I have shared with you both the presentation.
Okay, ma'am, I'm just sharing in a minute.
Please open the first one, that is how to draft writ petition.
Okay, ma'am, the blue template, that one,
yes.
right?
Yes, that one. Presentation on how to draft it.
Yes, ma'am, I'm just sharing it. Please tell me if my screen is visible.
Yes, ma'am, it's visible.
All right, thank you for confirming. Ma'am, you may begin.
Okay. So we will start on this topic, how to draft a writ petition. So there is an introduction part on this first page. So as we all know, writ in India is a formal order of the court directing the authorities if there is a violation of our fundamental rights by a government authority or a body. Government authority, by government authority, we are talking about the authority that is given under Article 12 of the Constitution of India. Article 12 जो है Constitution का, उसमें government जो authority का definition है, that has been provided. The definition of state has been given. उसमें ये सब है. You can file a writ petition in Supreme Court under Article 32 of the Indian Constitution, whereas you can file the writ petition in High Court under Article 226 of the Constitution of India. You can also file a writ petition in India for a civil or criminal act. As we all know, हमें ये law के starting days में जब constitution law subject होता है तो ये पढ़ाया जाता है कि article 32 में हम Supreme Court में अगर हमारा कोई fundamental right violate होता है तो we can move before the Supreme Court, and High Court में हम under article 226 के जा सकते हैं. You can file a criminal writ petition when the cause of action in relation to the criminal law, such as a right of accused, bail, etc. Bail के लिए भी you can approach directly to the High Court. लेकिन according to procedure you have to exhaust the remedy first before the session court. लेकिन then आप जो है High Court में जा सकते हैं अगर आपका session court में reject हो जाता है. Accused के rights होते हैं जैसे habeas corpus आपने सुना होगा. You may have the body. अगर हम सुने तो मतलब 24 घंटे में जो होता है जो अगर एक पर्सन को अरेस्ट कर लिया है तो he has to be produced before the nearest court. लेकिन अगर वो नहीं होता है तो उसके बिहाफ पे कोई भी पर्सन जो है वो habeas corpus जो है writ petition वो फाइल कर सकता है. We will discuss these 5 kinds of writ जिसे हमें mostly पढ़ाया जाता है. There are 5 writ petition types in Indian Constitution which you can file either before the High Court or Supreme Court. So number 1 is habeas corpus. Number 2 is mandamus, do your duty. जब do your duty जो होता है कि गवर्नमेंट को हम बोलते हैं कि जब गवर्नमेंट अपनी ड्यूटी सही से परफॉर्म नहीं करती है तो देन वी फाइल द मैंडामस, लाइक रोड प्रॉपर नहीं कंस्ट्रक्शन हो रही है या फिर इस तरह की कोई प्रॉब्लम हो तो यूजुअली हम मैंडामस में फाइल करते हैं, मैंडामस रिट फाइल करते हैं जिसमें कोर्ट जो है कोर्ट पिटीशन मैंडामस पिटीशन इशू करता है जिसमें वो कोर्ट कहता है गवर्नमेंट को टू डू योर ड्यूटी. थर्ड वन इज अ प्रोहिबिशन. Prohibition is to prohibit. Certiorari is to quash the order of the lower court or quash the order of any authority. Quo warranto is by what authority? तो इसको हम पूरा एक अच्छे से डिस्कस करेंगे one by one. First is a habeas corpus writ petition. Now what is this habeas corpus? The literal meaning of the term habeas corpus means you may have the body of. ये literal meaning है आपका. You can file this type of writ petition when a person is illegally detained. एक person का आपने देखा होगा कि आर्टिकल 20 जो है हमारे कॉन्स्टिट्यूशन में वो है जो इलीगली इंसान डिटेन हो जाता है उसके लिए कोई राइट है. तो अगर एक इंसान को इलीगली डिटेन किया जाता है सबसे पहले तो उसका ये राइट बनता है कि उसको 24 घंटे के अंदर अंदर नियरेस्ट जो मैजिस्ट्रेट होता है उसके सामने. लेकिन अगर वो इंसान प्रोड्यूस नहीं किया जाए तो कोई भी जाके हाई कोर्ट में हैबियस कॉर्पस रिट फाइल कर सकता है जिसमें वो कह सकता है यू मे हैव द बॉडी ऑफ, मतलब उस इंसान को जो इलीगली डिटेन किया है उसे कोर्ट में प्रोड्यूस किया जाए. If the court find out that the person is just a second. Okay, fine, Riddhi. So we are talking about habeas corpus, which means you can file this type of writ petition when a person is illegally detained. As I told you, when a person is illegally detained, you can file this writ petition before the High Court under Article 226 of the Constitution of India and under Article 32 of the Constitution of India before the Supreme Court. It means you can directly move to the Supreme Court, right? If the court find out that the person is illegally detained, then it can order for the release of that person. For example, when one file writ petition of habeas corpus in nature, then the court ordered the authority to produce the detained person before him to examine whether he or she has been examined legally or illegally, right? On conducting the examination, if the court find out that the person has been illegally detained, that it can order for the release of that person. So this comes under the writ of habeas corpus. What are the features of this writ petitions? Number one is court has an authority to ask cause of detention of a detained person. For example, police, in most of the cases, police detain a person without any reason, right? So if somebody has moved to the High Court and file this writ of habeas corpus, then the court has an authority. They can ask question regarding what is the cause of detention. Why do you detain that person, right? Number second, the court can issue a summon for the production of a detained person in the court, right? Third one is, if it is concluded that the detention of a person is illegal, it can order for the release of a person. The moment the court realizes that no, the detention is illegal, it can order for the release of the person, right? Now the format of a writ of habeas corpus is given. This format is given for the High Court, not under Article 32. That is in that case you can move to the Supreme Court. So format we will discuss later. Let's discuss the very basic points of the writs first. The second one is the writ of mandamus. So mandamus is a Latin word meaning we command, right? Mandamus is a court writ whereby the higher court orders the lower court, tribunal, forum, or any other public authority to do any act which otherwise also fall under the purview of their duty. So please try to understand, mandamus is a court writ where the high court orders the lower court. It is not only the lower court for which the mandamus can be issued. High court can order the lower court, the tribunals, the forum, or any other public authority to do any act which otherwise falls under the purview of their duty. The essential requirement of a mandamus writ petition for the court were described by Supreme Court in a case in Mani Shobre Jain versus State of Haryana. So it's a landmark case, 1977, SCC 486. The court laid down the following requirements of a writ of mandamus. What are those requirements? Number one, there should be a legal right in existence. There must be a legal right. Then only you can move to the under Article 22 for the writ of mandamus. The legal right should be enforceable by court, right? Enforceable by court means for which you can move before the court for its enforcement. Third is, enforcement of such a right must impose a responsibility of person on a person, public authority, corporation, or government. Such duty is of public nature. So these are some requirements that are laid down in this case, that is Mani Shobre Jain versus State of Haryana. Writ of mandamus can be issued against following. Now the question is, against whom the writ of mandamus can be issued? First is against an individual or against a private body. It is very important that it is not mandatory that only against a government body, only against a government authority, this writ of mandamus can be issued. It can only be issued against an individual or against a private body. Right. Second is, if the duty which is a subject matter is discretionary and not mandatory. If a duty which is subject matter discretionary and not mandatory, writ of mandamus can be issued. It can be issued against the president or governor of a state, against an acting chief justice. Even to enforce a private contract, a writ of mandamus can be issued.
Ma'am, the screen is not present to us right now.
Sorry?
The screen is not present to yet right now. The screen just vanished somehow.
Okay, Riddhi, can you please present the screen? I'm here in the writ of.
I'm just checking what the issue happened.
Yeah, the writ of prohibition.
Is it visible now?
Yes, ma'am, it's visible again.
Sure.
Thank you.
So we are on the writ of prohibition. That is number 3. So writ of prohibition, as the name suggests, the writ of prohibition is a court petition. It is a court petition which is either issued by Supreme Court or High Court to prohibit, as the name suggests, for writ of prohibition. It means to prohibit. Prohibition writ for the court is issued to stop or to put a stay on the power exercised by the authority, and is commonly known as a stay order. We usually have heard the stay order, right? In India, a writ petition is issued against the proceedings going on in lower court, or in such proceedings, the lower court is exceeding its power. When the lower court try to exceed its power, a writ of prohibition can be issued by High Court or Supreme Court, right? Against the lower court. Once the writ of prohibition is allowed, either by the Supreme Court or by the High Court, the proceeding of the lower court came to an end, right? The Supreme Court in the case of Govind Menon versus Union of India, AIR 1967, Supreme Court 1893, SC 1893, laid down the condition in which one can issue a writ of prohibition. Now, what are those conditions? These are the conditions by the court. First is where there is excess of jurisdiction. When a lower court try to exceed its jurisdiction, as we already discussed, right? Second is when there is an absence of jurisdiction, right? When you do not have any jurisdiction and you try to do under that thing, then you can also move under this writ of prohibition, and writ of prohibition can be issued by the higher court. Now, this is a format, and we will discuss the format later. Let's proceed with writ of certiorari. So in the literal sense, the word certiorari means to be certified. One can issue the writ of certiorari by the apex court for transfer of the matter to it or any superior authority for proper consideration. You can issue the writ of certiorari against the inferior court or tribunal. As same in case of prohibition, you can issue this writ of certiorari against the inferior court or tribunal. For example, a high court writ petition can be issued against lower district courts, right? In simple term, one can issue the writ of certiorari when the subordinate court or quasi judicial body act, number one, in the absence of their jurisdiction, number two, exceeds their jurisdiction, or fail to make use of their jurisdiction. In these three cases, writ of certiorari can be issued. In the case of State of UP versus Muhammad Noor, AIR 1958 SC 1816, the Supreme Court stated that one can issue the writ of certiorari to mainly reform the jurisdiction-related mistake of the inferior court or tribunal. Subsequently, in another judgment, that is Hari Vishnu Kamath versus Ahmad Ishaq, AIR 1995 SC 233, the Supreme Court held that one can only issue the writ of certiorari to correct the error apparent on the face of records, but not for the correction of an error of fact, right? What are the essential conditions for the issuance of writ of certiorari? Number one, there should be a court, tribunal, or an office having the legal authority to determine the question with a duty to act judiciously. Number two, such a court, tribunal, or officer must have passed an order acting without jurisdiction or in excess of judicial authority vested by law in such court, in such tribunal, or by in such officer, on such officer. Number three, the order could also be against the principle of natural justice, or the order could contain an error of judgment in appreciating the facts of case. Now, the last, I think this is one of the most important writ, that is writ of quo warranto. Writ of quo warranto means the writ that you can be issued to restrain the person from acting in the capacity of public office to which he or she does not have the entitlement. Here the term quo warranto means by what authority or on whose authority is one holding of this public office. For example, there is a vacancy in a government, right? And by giving a job to a 63-year-old person, they fill that vacancy. But since the retirement age is 60 years, so in this case, one can file a writ of quo warranto to remove such person from that public office, right? The Supreme Court in the case of University of Mysore versus Govind Rao laid down the requirement of the petition of quo warranto, which are these. Number one, a disputed post must be the public post. That is very important. That post must be a public post. Second one, the post should be held by a person without any legal authority. Number three, the office must be substantive one and not merely the function or employment of a servant at the will and during the pleasure of another. Right. Now, the very important, the basic part of this conversation, this webinar is to how to file a writ. So to file a writ petition in either of the court, whether it is a Supreme Court under Article 32 of the Constitution of India or under Article 226 before the High Court, a specific procedure need to be followed. What is that procedure? Firstly, the aggrieved party has to approach a particular organization with necessary document like it's his identity proof, his residential proof, photograph, etc. Right? Then there is a drafting of a petition with the help of a lawyer. First, you have to send a representation. This is how to file a writ petition. right? I think the last page, 14 number. So firstly is you have to give the representation to that particular organization with necessary document like identity, your identity proof, your residential proof, your photograph, etc. Then there is a drafting of petition. Obviously, if you want to draft a petition, you need the help of a lawyer. The draft, what does the draft include? The name and address of the aggrieved party, along with the fact that they lead to the violation of his or fundamental right. After this process, the draft of petition is sent to the court. Now it is up to you whether you want to file before the writ petition before the High Court under Article 226 of the Constitution of India, or before the Supreme Court under Article 32 of the Constitution of India. One thing here is very important to note, that this Article 226 is wider than this Article 32, because in case your legal right and fundamental right or any of the right is violated, you can move under Article 226 of the Constitution of India before your High Court. But under Article 32, only you can move only when your fundamental right is violated, then only you can move to the Supreme Court under Article 32, not in case your legal right is violated, right? After this process, the draft of the petition is sent to the court. Now draft is ready. You have to send that petition to the court. Then the date of hearing will be set. Then what will be the next date of hearing? And on this date, the court accept the petition and generate a notice to the other party. What will be the other party, right? After this, a date is given to assure the presence of both parties, so that next day both the party will present before the court. That is why the notice is sent to the other party. Finally, after hearing both the parties, the court gives judgment and grant relief accordingly, right? So there is one principle that is audi alteram partem. You cannot give a judgment without listening to the other party, right? So you have to hear both the parties. Now, how do I file a writ petition in High Court and the Supreme Court? The last page. As discussed earlier, both civil and criminal writ petition can be filed in both the High Court and the Supreme Court under Article 226 before the High Court and under Article 32 before the Supreme Court. The stepwise procedure of filing a petition at both the High Court and Supreme Court is as follows. First, you have to draft a writ petition. After drafting, you can file the petition at the filing counter. Every High Court and yes, Supreme Court, there is a filing counter. You can file that your petition draft before the filing counter. On the date of hearing, the court will admit your petition and send a notice to the other party as discussed earlier. Then the court will fix another date for the hearing. This will be the presence of such other party if it choose to appear, right? So this notice is sent to make sure that the other party will present on the next date of hearing. Here the court will finally consider all the content of the petition and then granting relief accordingly, right? So I think that's all. We have covered almost main thing. If you guys want me to open the next presentation as well, I have made one more presentation. If you guys want me to open that one, please let me know so that I can discuss that one also.
In turns, you can ask your doubts one by one.
Yes, ma'am.
Okay.
Do you have any doubts?
If you guys have any doubt, please ask, or if you want me to, if you want me to open the other presentation that I have made, please let me know.
Yes, Akshay.
Ma'am, is it necessary to have a lawyer before filing the petitions in the court? Can an individual directly file?
You can move a writ petition by yourself as well. It is not mandatory, but yes, for drafting, obviously you need a lawyer, but it is not mandatory. You can, present, if you are an aggrieved person, you can directly go to the court without a lawyer. You can present in person before the court. Yes.
Oh yeah. All right, ma'am. Thank you.
Okay. Anyone else?
Ma'am, I have a question. You just mentioned the prohibition, like a rate. The rate was for the prohibition, and there is also a thing which is injunction, which is temporarily stopping from something or something like that. So, is this both thing are same or different? Can you just answer me?
See, injunction is for civil dispute as well. Like in civil cases, we file a stay order, a case of permanent prohibitory injunction, right? There is a civil suit. But in a this writ prohibition, you can, as I discussed, that it can only be issued against by the court under Article 226 and just a second, I have to. Just a second. Stay order in a simple civil case or a civil court, before civil court, you can file this case of permanent prohibitory injunction. But this is prohibition is something else. Prohibition is to prohibit the government authority, right? Let me open this.
Is the doubt clear?
Yes, ma'am.
Just a second. Let me clear your doubt. Actually, I am opening the PDF because I have. So yeah, it's a court issue to stop and put a stay on the power exercised by authority, and is commonly known as stay order. In India, writ petition is issued against the proceeding going on in lower court. So it is against the court. It is not against a private person. But in stay order, you can also file a permanent prohibitory injunction suit before the civil court, and you can take a stay order for against a private individual, right? But in this writ of prohibition, you can only file this petition to issue an order against the lower court, and when the lower court is exceeding its power, so it is only against the lower court that writ of prohibition can be issued, not against a private individual or a private authority, private body.
Okay, ma'am. Thank you.
Anyone is having any doubts? Do you want any draft to be shared with you in particular? Please in turns speak up, because your next assignment is going to be based on the same. So if you have any kind of doubts, you can ask ma'am now.
Yes, ma'am. If you can share the sample of the drafts, it would be good.
You want to be discussed over here, or you want me to share it in your groups?
The groups, ma'am.
Okay, all right.
Thank
That
you.
can be done. We'll do that. Any other doubt? Any question? Even if it's not regarding writ petition, you can ask any question regarding your career, anything else. It's a golden opportunity to interact with ma'am.
Please feel free to ask. It is not mandatory that you have to confine only on this topic only. You can ask freely.
Yes, ma'am.
Ma'am, I was just having a question. As a mentor just mentioned earlier, you were child
Your
home
voice
or
is breaking. Can you please repeat?
ma'am, as you're working for the child's for their well-being and other things, can you just tell me that in Juvenile Justice Act we have so many acts and various homes for the child? So does that laws work on the real life situations also, or just the laws are there and it's not implemented as we are understood or as we are told? Just
Yes.
can you just tell me the ground level differences?
May I know your name?
I am Monsis Chakraborty.
Monsi, I think this is a very important question, because I always discuss that there are so many laws in our country, right? We have a law to deal with the sexual harassment workplace. We have a law to deal with this Domestic Violence Act. We have every, we have POCSO Act, we have everything, Juvenile Justice Act. But again, the problem is in implementation.
Yes,
Under Juvenile Justice Act, it is mandatory that in every district there must be a JJ board, right? Juvenile Justice Board.
yes, ma'am. The committee.
But yes, the Child Welfare Committee must be there. The Juvenile Justice Board must be there. But basically, if I talk about my state, my area, that is Jammu Kashmir, here the child welfare committees in every district is actually not present here in Jammu and Kashmir. If I talk about this state only. So far as the Juvenile Justice Board is concerned, no doubt there are JJ's board who are working, but not actively. There are some guidelines that has been issued in 2021 when this COVID thing was happening by Supreme Court in a landmark judgment where Supreme Court has provided some guidelines that it is mandatory to be followed by every Child Welfare Committee and Juvenile Justice Board. I file a PIL before the J&K High Court, which is pending before Srinagar Bench right now. Not even a single, I would say, not even a single line has been followed by JJ Board here in Jammu and Kashmir and Child Welfare Committee. So I must say that there are strong piece of legislation. We have strong piece of legislation, Juvenile Justice Board. We have Child Welfare Committee that is mandatory. In every district, Child Welfare Committees must be there. But I don't think it is properly implemented because sometimes staff is not available. Sometimes it is like we have, there are so many child sexual abuse has risen during this COVID time. You must have heard that NCPCR, National Commission for Protection of Child Rights, and National Commission for Women have issued a data in which they said that during this COVID time, this child sexual abuse and domestic violence abuse has risen. But whether any action has been taken by the concerned authorities, like the Juvenile Justice Board is specially meant for those juveniles who are in conflict with the law, right? So I think there must be proper implementation of every law, whether it is Juvenile Justice Act or whether it is any other law. There must be proper implementation because we have so many judgments given by our Honorable Supreme Court where it is mandatory to be followed by some agencies like police authorities and this child welfare committees for the welfare of children. But whether it is properly implemented or not, this is a main question. I think that should be followed. That is for which you can file a writ. I think we have discussed this writ petition today, how to draft this writ petition. That can help a lot. This is actually for the welfare of this public. You can file a public interest litigation for the same, for a genuine cause, right? Yes, Monji.
Yes, ma'am. We can file a writ petition like the mandamus where the government is not actually working according to the law or where they are not taking certain steps. And as you just mentioned, there are not healthy number of staff present. Ma'am, we are having an unemployment situation in our country, right, which is happening for a lot of time. So don't you think it's just a contradictory fact, like we don't have staff and on the other hand, we are facing unemployment also?
Absolutely. I think this is one of the main reasons that we do not have staff. In fact, there are a number of cases pending in courts, but judges are not available, right? Judges are not there. So I think this is a main cause, but see, we have, under IT Act, if you have heard about the IT Act, there are mandatory that in every district, a cyber cell must be there. But in, if I talk about the Jammu Kashmir, there is one cyber cell in Jammu and one in Srinagar. Now, what we say that there is unemployment, it doesn't mean that the law says when a law is, made by a parliament, then it is when the law is framed, it is a duty of the government only to create the post for that particular purpose. If you have framed a law, that is a duty of the government to create a position, the post for that particular purpose. If you have a Juvenile Justice Board in every district, if you have Child Welfare Committee, why staff is not there? Then what is the purpose of making this Juvenile Justice Act if you do not have any staff? I think this is a This is unfortunately, this is the reality of our country, but that should be, cured by some initiatives if taken properly. Like Supreme Court recently, as I told you, that in 2021 Supreme Court, given a very detailed guideline that every JJ board and every CWC must have implement those guidelines within their premises. But whether that guideline, as I am talking about Jammu Kashmir, it has not been implemented. I filed an RTI regarding this, but get an information that not a single guideline has been implemented in their in the boards and committees. So what is the purpose of that guidelines? Right. Yes.
Any other doubts? Okay, I think there are no more doubts, ma'am. So I will proceed ahead with the vote of thanks. On behalf of Team Law Internships, I, Riddhi Jindal, would like to extend my heartfelt gratitude to Ms. Meenu Pada, ma'am, for joining today and taking out time from a busy schedule and interacting with the young minds. Thank you so much, ma'am. It was a wonderful session.
Thanks for inviting me, Riddhi. Thank you so much.
Thank you so much.
Okay.